All right. Good afternoon, everyone, and thank you all for being here today. On behalf of LegalPay, I would like to extend a warm welcome to all our distinguished panelists, industry professionals, and guests for joining us today for this discussion. Today's conversation revolves around a concept that is steadily transforming access to justice and the economics of dispute resolution: third-party funding. At its core, third-party funding is a fairly simple idea. It allows a third party in a legal dispute to receive financial support from an external funder who covers the cost of the pursuing their claim, whether those are legal fees, expert expenses, or arbitration and enforcement costs. In return, the external funder receives a share of the recovery if the case succeeds. And more importantly, if the case does not succeed, the claimant typically does not repay the funder. This makes third-party funding a non-recourse investment, transferring a significant portion of the financial risk away from the claimant. But while this model may sound modern, its roots actually go back several centuries. Historically, legal systems were cautious about outside involvement in litigation. In medieval England, doctrines such as maintenance and surety prohibited third parties from funding lawsuits due to concerns that wealthy individuals might manipulate the legal process for profit. However, as commercial disputes became more complex and costs of handling disputes increased, jurisdictions around the world began to reconsider these restrictions. The modern third-party funding industry began to take shape in the 1990s, particularly in Australia, which is often credited as the birthplace of the contemporary funding model. From there, the concept rapidly expanded into other jurisdictions such as the United Kingdom, Singapore, Hong Kong, and several parts of Europe and North America. Today, litigation funding has become a multi-billion-dollar global industry, widely used in international arbitration, commercial litigation, and insolvency matters, or even class actions. More importantly, it has shifted the conversation around disputes, from seeing them purely as cost centers to recognizing legal claims as assets that can be financed and managed strategically. In India, we are also witnessing growing awareness and acceptance of this model. While third-party funding has long existed in principle under Indian law, the structured and institutional form of third-party funding is only now beginning to gain momentum. And LegalPay is working at the forefront of this evolution, helping businesses and individuals pursue meritorious claims without being constrained by financial barriers. Which is precisely why conversations like this are so important, because third-party funding sits at the intersection of law, finance, and access to justice. Over the course of this session, we will explore how this model works in practice, how it is shaping dispute resolution globally, and what the future may look like for third-party funding in India and beyond. That we've briefly touched upon the evolution of third-party funding and its growing relevance in today's dispute resolution landscape, it's time to hear from our experts who are actively shaping this space. We have with us an excellent panel of speakers who bring diverse perspectives from across the legal ecosystem. Our panelists today have extensive experience across commercial disputes, arbitration, litigation strategy, and investment in legal claims. And we look forward to hearing their insights on how this industry is evolving, particularly in the Indian context. I'll begin by introducing our panelists for today. First up, we have Mr. Shashank Garg. Mr. Garg is a senior advocate, arbitrator, and author, and a leading figure in the field of international commercial arbitration and dispute resolution in India. He currently serves as the chair of the ICC International Court of Arbitration in India and has played a significant role in promoting India as the global arbitration hub. He is also the secretary of the Arbitration Bar of India and vice chair of the Society of Construction Law in India. Mr. Garg has played an important role in shaping India's legal landscape with respect to third-party funding, having successfully represented a third-party funder in the landmark judgment of Tomorrow Sales Agency Private Limited versus SPS Holding, which laid down authoritative guidance on the legality of third-party funding in India. Sir, we are honored to have you with us today. Our next distinguished panelist is Mr. Divyakant Lahoti, advocate on record before the Supreme Court of India. Mr. Divyakant Lahoti is widely recognized as one of India's leading commercial dispute resolution lawyers with a distinguished practice spanning complex litigation and arbitration in the fields of infrastructure, real estate, energy, and intellectual property disputes. As a member of the United Kingdom's Chartered Institute of Arbitrators, he regularly appears in high-value domestic and international arbitrations, representing major corporates, institutions, and stakeholders in commercial matters. Mr. Lahoti has played a pivotal role in strengthening India's arbitration ecosystem and has been instrumental in the establishment and development of the Arbitration Bar of India, contributing significantly to the advancement of institutional arbitration and professional training in the country. We are very glad to have you with us today, sir. Our next panelist is Mr. Sameer Jain, founding and managing partner of PSL Advocates and Solicitors, a premier boutique dispute resolution firm with offices in Delhi, Bombay, and Chandigarh. Mr. Jain is a highly respected dispute resolution lawyer in India, widely known for his expertise in international commercial arbitration and insolvency law. He is also a registered foreign lawyer at the Singapore International Commercial Court. Mr. Jain is currently serving as the Joint Secretary North of the Arbitration Bar of India and is a delegate to the ICC Commission on Arbitration and ADR. Mr. Sameer Jain has represented multiple clients in high-value cross-border disputes across the sectors such as oil and gas, power, defense, and infrastructure. Sir, we are delighted to have you with us today.
Thank you.
Our final panelist is Ms. Amrita Grover, Vice President Litigation Funding at LegalPay. Ms. Grover joins us with over 10 years of experience as a practicing counsel, primarily on the commercial side, with a strong focus on infrastructure arbitration matters across both domestic and international forums. Having built a solid foundation in litigation, she has recently transitioned into the realm of third-party funding, joining LegalPay with the aim of helping make third-party funding a more accessible and commonplace concept within the Indian legal landscape. We are truly glad to have you with us today, Ms. Grover.
Thank you.
Thank you to all our panelists for joining us today to discuss third-party funding in India. As we move forward, we will begin the discussion with a few foundational questions to build a broader perspective for our audience, and all audience members are invited to raise their questions in the Q&A section. My first question is on the legal framework of third-party funding. From the historical restrictions to becoming a structured financial tool in several jurisdictions today, how do you see the current legal status of third-party funding in India, particularly when viewed against its historical evolution? Ms. Grover, could you share your thoughts on this?
So basically, the third-party dispute funding in India traces back to the colonial period, where the courts had addressed the doctrines of maintenance and champerty. So the first law that was laid down by the Privy Council was in the Ram Kumar Kundu judgment in 1876, where it held that the finance litigation format in where there was a return of the share of the proceeds were not per se void, unless there were there was extortion or it was absolutely contrary to the public policy. This principle was then carried forward in 1940 with Lal Kumar Sarup judgment, which was again a Privy Council judgment. So this has been developed. This principle has been developed in the colonial times. Then it was further brought about and made a part in the Civil Procedure Court, where we see its prevalence in the Order 25 Rule 1 and 3, which are there with a few states, but it's not present for all the states, but a few states like Maharashtra, Gujarat, Madhya Pradesh, they have this Order 25 Rule 1 and 3, which allows courts to order security of cost from a person who's financing the litigation on behalf of the plaintiff who is resident outside the jurisdiction or lacks sufficient means. So there is I cannot say that there is an accepted principle there, but there is a semblance of acceptance of a third party. It is not to be considered something which cannot be done. After that, the latest law which had come was in 2018 with the Supreme Court laying down law in the A.K. Balaji judgment, where it was defined that in case an advocate is not there, if it is an advocate cannot fund it because we have the Bar Council rules, so advocates themselves cannot fund it. They cannot have a part in the proceeds of the dispute. However, a third-party unrelated funder can very well fund disputes, which has now come to it is suitable for all the people who have lack of funds, the natural funds available for fighting the disputes, because they are all becoming high value. They're becoming with the development in a country like ours, there's less infusion of money into. Sometimes, if I'm running a business, let's say I have a construction business, now I have to give a bank guarantee to continue with the new project. However, if I withdraw all of that money and invest it in a dispute, it results into my working capital being reduced or squeezed to maximum. So in those concepts, this framework needs to be developed, and that is what our generally what has come before and has been developed by the courts in India. I think Mr. Garg would be more qualified than me to discuss, because he's the lead author and the lead counsel in the Tomorrow Sales judgment. Sir, if you could enlighten us.
Thank you. Thank you, Amrita. So, as you have already captured the background and the history and evolution of third-party funding in India, what one would realize is that these judgments, whether it is A.K. Balaji or whether it is the historical judgment in Ram Kumar Kundu, are more to say that there are no restrictions. So you get hints with respect to third-party funding uh, not being prohibited in India. But there was no express recognition of third-party funding as a concept, which gladly for the first time, subject to correction, was done by the Delhi High Court Division Bench in SBS, Tomorrow Sales SBS matter. Just to give a very brief background to the matter, and Samir has also joined us today, who had a major role in this matter at the time of the arbitration. He was representing one of the parties who was funded. So this was an international commercial arbitration, the Singapore seated matter, where one of the parties which was being funded by the Indian funder had lost the arbitration, had lost the claims. And thus there was a award of costs against that party. Now the winning party decided to file a Section 9 before the Delhi High Court to secure that cost amount, not only through the award debtors, but also making third-party funder a party and saying that the cost should also be recovered from the third-party funder. Unfortunately, at the level of the single judge on the stage of interim, we being the third-party funder, faced an adverse order where disclosure was asked by all of us, including the third-party funder, and the court decided to, the sequitur to that would have been that the funder would have been made liable to also pay the cost in addition to the judgment debtor. We went in appeal before the division bench, and division bench set aside that order on two grounds. Number one, since Section 9 is always Section 9 post award is always in aid of the execution. Thus, what you can execute has to be what the award says. And the award had nothing with respect to the third party funder. The award was made only against the judgment debtor. So there cannot be an additional ground, additional prayer in a Section 9 proceeding that you initiate before the court post an award, which is not there in the award itself. But since the topic today is third-party funding, I'll confine myself to the discussions regarding that. And the division bench, while dealing with this aspect, also dealt with the concept of third-party funding, went on to say that in the modern legal world, third-party funding is a mechanism to ensure access to justice in the commercial litigation and dispute resolution space. So this was a big landmark ruling, which I recall was celebrated not just in India, but across. Another development with respect to this that I must tell your team as well as people who have joined us today is that then this was taken up in Supreme Court through an SLP, and the court on day one had granted leave, saying that this is an important matter which requires consideration, and thus we would like to hear it, not commenting upon the merits of the division bench judgment. But as it stands today, the party who had challenged in the SLP has now finally withdrawn. So the law of the land as it stands today is the judgment of the division bench. So there is absolute clarity with respect to the concept of third-party funding, and there is express recognition of third-party funding now in India.
Great. Thank you both. That really sets the foundation for this discussion. Let's bring in another perspective here. From a practitioner standpoint, how are courts and clients in India currently responding to the idea of litigation funding? Mr. Jain, could you share your thoughts on this?
So as far as courts is concerned, I think Amrita and Shashank have
giving a fairly detailed vision to what the courts in India think about third-party funding. I can only say the courts have been extremely positive. The idea of third-party funding has always been said not to be alien to the Indian jurisprudence. The idea has always been there. The only problem was that there was no express recognition which came by way of the Delhi High Court judgment in tomorrow sales. So there is no qualms in saying that the courts are extremely positive. As far as clients are concerned, I have personally felt clients love the idea of getting their disputes funded. Earlier, the disputes were funded for parties who did not have money to really contest the case and pay the fees for the tribunal or the lawyer or the court fees. But the recent trend and the interesting trend is that even parties who have their monies there with them are also adopting funding, basically to ensure that their working capital is not stuck in funding a dispute, which otherwise can be funded by a litigation funder. So the clients, in my view, are becoming very acceptable to the idea of funding. The only problem which I see in India is that there is a huge need of education, client education, in third-party funding. How third-party funding is done. What are the nuances of third-party funding? How exactly do you recover the fund? The basic problem is the clients always think, because that's how traditional financing works, that you have to provide security for the money you received for funding. The clients need to understand that this is not really funding a dispute, this is investing in a dispute. That's the fundamental differentiation between loan agreements, financing agreements, and investment agreements. So every dispute for a funder is an investment vehicle, or it's and there are returns if their funding or the funded matter is succeeds with recovery. So I think one that is required, client education is required, because I have come across unstructured funders who say that you give me security, you give me posted checks, or you put up a property for the funded amount, though we won't use it, but it's just for safety, which is not how funding works. This is not how internationally funding works, and it ought not to work like this. So and clients in India are primarily divided into sections. One, there are clients who are claimants in a foreign seated arbitration against a foreign respondent. So you're funding an Indian party, but you're funding a dispute outside of India against a party which is outside of India. So a decision of a funder to fund a dispute or not fund a dispute, essentially the three things which a funder would look at, which clients ought to know. One, of course, the merits of the dispute. Second, the forum in which the dispute is being contested. Is it court? Is it arbitration? Is it tribunals? Third, who is the respondent, and does the respondent have the financial capacity to pay up the award if there is an award in favor? A funder normally will not fund a respondent which does not have assets if there's 100 million award against them. And fourth, and most importantly, is the jurisdiction in which these respondents located. Are you going to enforce an award in a jurisdiction where it takes 5 years to enforce a decree or an award? Or would you want to go fund a dispute for a respondent which is located in a country where enforcement takes 1 year? So it just changes probably the risk parameters, the return parameters. These are all variables to calculate on a system, and then probably figure out how exactly you want to do this. And lastly, what's required possibly in India is regulation, or more or less self-regulation of funders in India, because of many such funders existing who are not structured, who are coming out with a unique method of security plus non-recourse plus investment and a financial. It's a mix-up. So, and I think the country is working. There are a lot of lawyers, firms, funders who have come together to, kind of, an arbitration bar of India, of course, is also looking at, bringing out regulation. So it's interesting. I think that the future for funding in India is fairly bright, and we will have some regulations, and clients will have better understanding of the sector.
Excellent, sir. Excellent. Building on that discussion, I'd like to come back to the future of third-party funding in India. Mr. Lahoti, what do you think the next 5 to 10 years might look like for this industry? And what kind of regulatory or institutional developments could help the ecosystem mature further?
Hi. So I believe that the current Indian position on third-party funding can best be described at this stage as permissive in principle, fragmented in structure, and cautious in application. So this is what makes the Indian legal landscape quite interesting. We still do not have a single comprehensive parliamentary statute governing third-party funding. Instead, the framework has evolved through three broad channels. Firstly is, as Shashank and Amrita have told about, judicial recognition.
Yes.
Balaji's case, then the SBS case, which recognize that non-lawyers can fund the litigation, but lawyers are prohibited. The second is the procedural recognition in certain civil procedure amendments that allow courts to bring a financer on record and seek security for cost. And third is the institutional arbitration rules that increasingly insist on the disclosure and the transparency requirement. So in a sense, India has moved from suspicion to acceptance, but not yet from acceptance to full regulation. The Indian position is clearing the cloud. It says outside capital may fund the fight, but the lawyers cannot become the investor in the dispute. So in my view, the next 5-10 years are likely to be the institutional building phase for third-party funding in India. The first hurdle would obviously be legitimacy, which has been crossed by way of the judgment of the Delhi High Court, in which Justice Bhakru was instrumental along with Shashank and Samir and their team in Tomorrow Sales matter, which has further recognized that third-party funders can serve an important access to justice function, while also emphasizing on transparency and the need to avoid exploitative funding structure. So at the institutional level, the developments such as MCIA rules of 2025, SIAC rules, both of which require disclosure of funding arrangements, show that the market is steadily moving forward from informal acceptance to a structured recognition. And if this trajectory continues, I believe that India will witness more mature and selective funding market rather than speculative one. And the funding is likely to grow first in high-value commercial arbitrations, enforcement proceedings, and strong monetizable claims where the recovery prospects can be assessed with discipline. So over time, the industry is more likely to become sophisticated and data-driven, with greater emphasis on what LegalPay is doing, rigorous case screening, portfolio-based funding models. It could be adverse cost risk allocation, and the pricing models, which may be linked to time, enforceability, and the recovery risk. So the real growth will come when the funders, law firms, and the arbitral institutions begin to treat these third-party funding not as an unusual arrangement, but as a normal and a credible component of dispute finance strategy. So in my humble view, India now needs a measured regulation instead of a heavy-handed regulation. And what remains unfinished is the broader regulatory architecture. And the most important developments would include a clear statutory or a model framework recognition of third-party funding. That's number one. Second is a mandatory disclosure of the existing funding, the identity of the funder, whether the funder has assumed any risk or adverse cost liability. Third, express conflict of interest rules dealing with the relationship between the funder, the counsel, the arbitrator, and the experts. Fourth could be the guidance on privilege and confidentiality, especially where sensitive case materials is shared with the funder, which may affect the share prices of that company. And we have to be very careful about a lot of sensitive data and avoid insider tradings on that particular funding arrangements. Then this has to be done on a principled and a more streamlined framework on securities of cost. And lastly, I think, which is important from LegalPay and other funders' perspective, that there should be a clear limits on the funders' control, particularly in relation to litigation strategy and settlement discussions. So these kinds of guardrails would bring greater transparency, fairness, and certainty to the system without stifling innovation. The real task, I think, in the next decade in the legal profession develops in a manner that is transparent, ethical, and institutionally reliable, so that third-party funding strengthens the access to justice without compromising on the integrity of the process. So that are my 2 cents on this regulatory framework.
So that's a great insight, sir. We've actually received a question from the audience. Ms. Dover, I think you will be able to answer this. From an investment perspective, are there particular sectors or type of disputes that tend to be more attractive for third-party funders?
So since, as Sir said, Divkant Sir said that, we have started with high-value disputes with strong legal case, where there's a very strong legal case. Where the client per se lacks financial resources to fund it. These are the kind of matters that these are the kind of people we are looking to help. Their disputes might involve commercial and contractual disputes. Let's say that there are shareholder conflicts, breach of contract, joint venture disagreements, infrastructure projects that have fallen through. Because these are very substantial money claims. They involve substantial money claims, and mostly it is like employer or a contractor or a subcontractor, which is much smaller an entity with a smaller working capital and is fighting against a bigger company or maybe sometimes a conglomerate where they're funding the funds that they have as per for their disposal are maybe multifolds than one person fighting against them. Second very important field that we have been looking at is international arbitrations. Again, Indian person seated in India, shelling out that kind of money to pursue his claims internationally, it becomes very difficult at times. So since LegalPay has international investors on board, we are looking for international arbitration matters where the expense is also quite massive in that, one would be a counsel in India, then there will be a local counsel in outside wherever the country is. Then the fee is international level fee. The arbitrators are charging as per the international fee models. So that fee is very expensive. Then there will be international experts in that. So the costing of dispute actually is quite heavy and could involve maybe sometimes, for an Indian businessman, it might include the totality of his working capital in that. So those kind of cross-border disputes are something that we are actually very, very keenly, and we've seen a lot of interest from the investors or the funders in this. Then there will also be insolvency-related claims where, proceedings, anything related to the insolvency bankruptcy code, where, you have third parties can help the claim credit. Sometimes it's so that the creditors committee has some assets that could be recovered, but now they are bearing the burden of bringing those claims to life. So in those situations also third-party funding can make absolutely, make a very good sense. Thereafter, we've also seen intellectual property matters actually, patent disputes. Let's say that I'm a sole innovator and I have a innovation that I made, and now a company is using it. Now company has multiple assets and has bigger, it's got a bigger pool. Now me with my research and my small resources has to fight against a company with that scale. In that part, yes, third party funding makes absolute strength. It gives me strength to go and fight my dispute, because otherwise my financials will never be able to, I cannot hire the right, correct legal talent at times. I can be blocked by the company with multiple assets and multiple, a larger capital to deploy in the dispute. So to fight all of these, to even the odds in the courtroom, I think a TPF can actually support. Whereafter, then we have also seen consumer matters, class action suits, where, let's say there's a big construction company has not made my offices, which all of us invested in, and we don't have more money to now fund this litigation as well. So in those situations, third party funding can actually, it's a game changer. It will even odds. It will reduce the time which we are taking in India to maybe get to a result, because there is power at both ends now. Otherwise, mostly there would be power or legal talent or better legal talent being employed by a company, against which an individual person actually becomes much weaker. So those kind of matters we are looking to support. We've had the opportunity to meet a few people from bigger concerns also. Sometimes, they just want to share the burden of litigation financially, especially, I don't want to employ. Again, we've also got people who've approached to us and said that I want to show that I want to go through the scrutiny of a funder, where if the funder trusts me, that puts more burden in my case. Like it makes my case it's a court craft basically, to show that your dispute has been funded by a third party, and so it has some legal background, it has some legal strength, it has some viability. So those kind of court craft also we help with. So that's not the primary aim, but yes, in eventuality that has that effect. So that's the kind of disputes we are looking. If I missed anything, sir, please let me know if you think that I missed any kind of dispute that we should have been seeing as a funder.
In fact,
Would you like to add something?
So, can I just add to what Amrita said? I
Please,
think
sure, sir.
the subject areas and the spectrum that Amrita discussed is quite exhaustive. Some of the disputes, in fact, even I had not thought would be supported by a third-party funder, especially consumer cases. It's a very fresh and interesting take. One would have to see how that pans out. But essentially, to answer your question, I think Sameer covered it up very well, that a funder would look at merits for sure. And then the funder would look at predictability. Funder would like to know certainty in law and a likelihood of a positive outcome. Of course, you can't have certainty as to the outcome, but there should be at least certainty of the law that is applicable to that dispute. If there are circulars, or there are notifications, or there are provisions or local laws that are in play which are currently being challenged or reviewed in some court of law for their virees, that's the kind of dispute a funder would like to wait and watch and not get involved with. In terms of subject matters, in my practice, what I have seen is that infrastructure construction disputes have heavily benefited from third-party funders. And as Amrita said it in the end, a lot of times parties like to have a scrutiny of a funder only to show strength in their case, and it boosts their own confidence. They may still not take the offer from the funder if it doesn't make economic sense to them, but it does help them evaluate their case from an external third-party point of view. What would be interesting is to see how the third-party funders look at Indian market in times to come, and LegalPay should set an example for disputes that are 100% local. India-seated disputes, which ultimately would go to Indian courts. This is an area where we've seen the funders have been a bit reluctant in the past, given the uncertainty and the time that is required for execution and getting the money in your hand. So if the market gets mature, and mature is the key word. When I say market, I mean the third-party funders and the entire ecosystem for third-party funding should reach that level of maturity that they're able to also support local disputes. And while we have one judgment of the Delhi High Court, and we have discussed, as Samir pointed out, self-regulation, there is Indian Association of Litigation Funders in place. There is ABI, Arbitration Bar of India, who's actively bringing out SOP that may help third-party funders. And as Devakant mentioned, of various institution rules that require disclosure and mandates certain things that must be done in case you're getting funded. So even Indian institutions like MCI already has set up, and various other institutions are also mulling over this. Once we have all of these steps taken, this is not in future, this is happening as we speak. So we will see the results of this very soon. I think the third-party funding market for India will be far more mature than it is. And of course, we have this discussion because it's no more a thing of future. It's nothing about it is speculative. It is legal. It is valid. It is for here to stay. We just need to ensure that the funders do the right thing. And very interesting aspect that was mentioned by Samir is unstructured funding agreements, mushrooming of small-time funders who may be looking at these disputes more from a in a predatory manner, which may lead to complications. And we've seen the government has reacted and sometimes overreacted in the past. We all know arbitration is facing one such challenge. So it is required that the funders act in a very matured manner, while there is no regulation to regulate them, self-regulate till that regulation comes in.
Just 2 quick points before we move on to the next question is, one very important role of a funder, which funders particularly don't like, is when funders are a lot of times used, or rather it's natural, and we've seen that once you end up deciding that you're funding a dispute, it leads to a quicker settlement. And it's a pre-dispute settlement, because a respondent who's aware that a matter is getting funded knows that a funder would fund a matter only when they have gone through extreme scrutiny by multiple lawyers and an investment committee. So I've come across cases where matters got settled, and in those cases, funders possibly have a different arrangement, that if there's a pre-dispute settlement, then there'll be a certain percentage. Or I've also seen in foreign jurisdictions, funders will sign an exclusivity and will put a certain cost for their due diligence in case the matter doesn't go into dispute. In case the funder is left before a dispute goes to arbitration or litigation and there's a final award. So essentially, in a pre-dispute settlement, there can be a certain cost. The second point is, there's a globally, especially in UK, there's a developing argument that funders should be made liable for costs. While argument on one side is access to justice, argument from the other side is that very well, you have enabled someone to access justice, but in case they lose and a cost is awarded, which naturally is mostly in all cases in international arbitration, where will the respondent go to recover that cost? Well, of course, one option with the respondent is to file an application for security for cost. The other argument is that funders should automatically be made liable to pay the cost of the arbitration. Unfortunately, that's what we also saw in Delhi High Court, the single judge's order. So in those cases, very few parties know that there is something called an adverse cost insurance. So there are a set of entities which act as third-party funders, and then there are a set of entities which act as third-party adverse cost insurers. So that money is either paid by the funder firsthand, or it just becomes slightly more expensive to fund your dispute when you have a third party, adverse cost insurer. So these concepts or these facilities are also available. So if you're looking to fund a dispute with the risk that a funder might be laden with cost, then consider having an adverse cost insurance as well.
So one more point which Amrita just concluded regarding the areas where third-party funding can still be explored in India is patent infringement litigation, which
Yes.
is a strong candidate for third-party funding in India, and it's already in vogue in US and other developed jurisdictions. I remember I did one HKIAC-based arbitration in 2015 where patent litigation was involved, and our company was in fact investing in the litigation prior to the trial and saying to the patent owner that you don't worry, we will invest in the litigation, and whatever is the settlement amount by virtue of note purchase agreements, forward agreements, we will enter into a settlement with the who's infringing. So these kind of matters, patent matters especially, are capital intensive, expert driven, prolonged, which means that even a party with meritorious claim may hesitate to litigate without financial support. At the same time, patents are commercial assets, and infringement claims often present a quantifiable recovery model based on damages, royalties, and settlement value. So that makes a patent litigation a natural fit in a well-structured third-party funding ecosystem.
Yes, sir. So in fact, when we have also come across patent disputes, we have actually come across people who are already being by these traditional. If the legal third-party funding as a concept is very different from the traditional financing that used to happen. The traditional financing where collaterals, as Samisa said, that you can keep a collateral and you can put in some money. So those kind of arrangements, we already seen, in fact, people coming with those arrangements and saying that, okay, this person is actually, now I am under extortion. Now you tell me what to do. Now that adds another layer. So this unstructured part of TPF actually makes it difficult for us to also evaluate. I mean, we have a cohort of lawyers like yourself where we can actually, take research from. We have experts like in India, internationally, where we can seek opinions for, let's say, like maybe an algorithm being patented. We can seek opinions, etc. But that additional cost plus the additional cost that the person is already incurring from the unregulated financer, which has come up as a funder as such, it becomes extremely difficult for us to streamline that and sometimes even fund these disputes because there are too many costs and too many problems involved. So structuring the TPF format in India will actually help us also identify and help them genuinely, obviously I will not say that as a representative of the investors. I will not say that I understand it's a no recourse funding. If I'm giving money, I'm not asking for anything from you guys to pay to me. As a client, nothing has to come from you. But in between, if you have these problems, then it becomes exceedingly difficult for me to involve myself in such, or to involve an investor to say, okay, we'll be giving money, then you first get rid of this person. Basically, funding is working in two formats. One would be a simple TPF format where your dispute is there. I'm going to pay all the funding requirements, including fee, court fee, arbitrator fee, expert fee, or your lawyer's fee, senior advocate's fee. Everything we will be taking care of, including the miscellaneous of court clerks and photocopy. Everything I will pay. But when we come to that arrangement, it's a very simple arrangement. Whenever there is a process, wherever there's actual recovery of funds is when I will get the pre-decided percentage. In those formats, we've also had, like Samisa said, if there's a settlement, then whatever is the capital deployed, mostly a 3 to 5x is what the investor looks at in this vertical, because these are basically exclusive verticals which are not subject to market risk or risk of valuation of property, etc. It's a diverse class of investment for them. So these are the average returns that they're looking at. You can have a waterfall arrangements where expenses come before, or expenses are paid at the time, finality time, or it can come in before. So these kind of arrangements we do enter. For a settlement, so mostly we have a percentage arrangement where we have a multiplier arrangement. Let's say before the dispute, if I've not made much expense, a 3x or a 2x is what is expected. Now, these formats, if there is no regulations or there is not a support work here, if there's already financiers included, then these arrangements, they can't work. So for this to come very fast and very soon to have a regulation will help us making all these formats workable very well in the to support this industry.
Well, very well. So actually, there's a question from the audience, and I believe Mr. Sameer Jain, since you have experience in this space, you would be able to answer this best. How relevant is litigation funding in the insolvency space?
See, litigation funding is relevant in every space where there is recoveries of money, and then there is the person who's pursuing the claim doesn't have enough resources. In insolvency space, that entity normally is the resolution professional of a company which itself doesn't have funds, or the COC is not willing to put in a lot of money. And one interesting aspect, and I'm still going back to the tomorrow sales judgment, is because one of the claimants in the arbitration was a company which was under insolvency. So possibly this was the first case which was first case of a claimant which was insolvent under the IBC and then got a dispute funded in Singapore. So we had the arbitration going on. When we disclosed, we had to go through this whole process of getting approvals from the RP supported by the COC. So it is quite relevant. Of course, there is a lot of money stuck, and IBC litigation is not an inexpensive litigation, and there are multiple fronts of this litigation. There's normal litigation which is going against debtors, which the RP has to fund. Then there is litigation by the RP against maybe promoters or the former shareholders, directors for avoidable transaction, for undervalued transaction, and recoveries of all the monies and assets. So of course, there is a huge scope in this particular area for funding disputes. But the only problem which I've seen funders experiencing is the uncertainty of or the delays in NCLTs, in NCLATs, in getting disputes and applications disposed of, and the idea of enforceability. So, but I think experienced funders are navigating it through proper due diligence, proper contracts, and I am hopeful that this will be an area which will also pick up steam alongside modes of funding.
Great. Any other panelists who would like to pitch in?
I think this first answer was very detailed. We can go to the next questions. We have a few questions that have come.
Right. So there's another question from the audience, and which is quite relevant, because even though Amrita has mentioned that there are a plethora of sectors that third-party funders would invest in, but it seems to be the pattern that arbitration is always the one that has been favored more. What exactly could be the reason for this?
Third-party fund is usually more attractive for arbitration because arbitration offers, in our limited experience, greater predictability in timelines, procedure, cost, confidentiality, and enforcement. So from a funder's perspective, that makes dispute easier to assess, price it, and monitor. Court litigation, on the other hand, and we all have our own cups of tea in respect of court litigation and arbitration. Court litigation is often exposed to heavier delays, procedural red tapeism, multiple layers of appellate jurisdictions. So while both can be funded, arbitration is generally a more efficient and commercially viable funding product. So second, arbitral awards are subject to challenge only on the
Yes.
limited grounds. Unlike court
Yes.
proceedings, which may travel through several tiers of appeal, both on question of law as well as on fact, that makes the enforcement and recovery pathways more predictable in arbitration, which is extremely important from the point of view of the funding house and the funder evaluating the returns on his or her investment.
So, in fact, in this, sir, I'd like to add, because what happens is that mostly when this first model is obviously the litigation, the dispute funding model that we have, where we fund the process. The second model, sir, that we mostly employ is a recompense model, in which there is, if there is an existing arbitration award, and which might not be under challenge. So we have also we also have offered upfront money in that, some part maybe, and then we have a back-end divide of the proceeds which will come. In those processes also, sir, so the degree of the first court in India is still, because it is susceptible to so many challenges and so many appeals, that there's, from the investor's perspective, there's obvious risk in that, which otherwise in arbitration we presume to be a lesser risk, because the appeals are restricted. Section 34 is very restricted, then 37 is even further restricted. So that way we have some surety of this surviving. And the 36 process is also considerably faster to reach at than the normal civil suits. In fact, Commercial Courts Act has brought about changes where we have limits to delays being for the filing of written statement from the defendant's end. But still there, I feel there is a little lag in that process still. And that is why, when we do the recompense model for commercial side disputes also, still the kind of arrangement that a client is looking for is not what they can eventually secure. For example, RERA matters have come, where we are looking to have a recompense model. Now, RERA matters have been pending since 2016 or maybe 10 odd years now. It's at execution, still execution hasn't happened. So in those fields where we are trying to support, but we still can't give a clarity, we still do not reach a clarity. Maybe those points can be sped up. There can be a speed. We can put in better gear there as a TPF. But still, from investor's perspective, it becomes a very dicey, and the commercials go to something which might look actually not that conducive for the client. So those kind of things.
Can I just add one thing? I think
Yes,
the stark difference as far as India is concerned between litigation and arbitration for a funder is the budgeting in terms of the legal costs that they will end up paying. You can easily budget for an arbitration, the set of counsels, the length of the arbitration, the arbitral fee that is going to be charged. If there are experts to be involved, all of that is ready on day one. In litigation, there is absolutely no way you can predict that cost. Even if there is a law firm who has given you a budget, there is a change of law, change of roster. There could be next set of senior counsels who have to be roped in. So it's an endless process. It can never be budgeted the way it can be budgeted in arbitration space. I think that remains one major factor that makes arbitration a little more conducive for funding. That said, I'm sure that LegalPay and other funders are also actively looking at litigations to be funded, but that remains, in my opinion, one of the most important facets.
Right. Another question that we have from the audience is there are two questions that are related and actually about the international cases seated in India. So seeing that litigation funding is already well established in jurisdictions such as United Kingdom, Singapore, and Australia, If you could share your thoughts on how do you see India positioning itself within the global litigation funding ecosystem, and what lessons can we draw from these international markets in which litigation funding has already been established?
I think Samir would be the best person to answer
Sameer.
this.
So one, that is incorrect. I think Shashank and Vivekan, both of you have similar experience. So
We'll add after you
thank
have
you
said.
for putting me on spot. But now that you have, so I think internationally it's a fairly developed area. They're very mature when it comes to funds, funding. The funds are very properly structured. There are the billion-dollar funds. It's a $25 billion industry, and I have personally
Yes.
worked with funds who have a corpus of $2 billion and $3 billion, and they also do a broad-based funding arrangement with lawyers and law firms, right? So they give them a credit line, and then they say we'll fund a smaller value dispute, because funds normally don't want to fund disputes which are very small. So it's a developed market. The funds are mature, the laws are there, regulations are coming in. Of course, the market and the jurisprudence is developing. As I said, there is a growing debate now why the funders should for adverse cost, and I'm sure there are multiple such issues and things which will keep on coming. And internationally, we will keep on possibly seeing that there is a good development. One interesting development which I have seen is, I think 99% of the cases when the respondent knows that the matter is funded, invariably respondent stops paying the fee for the tribunal. It's as if their fee is also funded, but
Funded, yeah.
and there have been immature contracts where this eventuality is not contemplated.
Yeah.
And before a funding arrangement is done, there is a budget. And if you exceed the budget, then there are multiple compliances under the contract, multiple reapprovals, going back to the investment committee again. So if you have not, really in a situation where if respondent refuses to pay, then what? Or if there is a security of cost application, and then there is, and in a case where a claimant is funded, an experienced tribunal in international arbitration will, for a given, give you an order for security of cost. So if there is a security of cost order, who's going to fund this? Because your arbitration is then stuck if there is a security of cost order and you do not comply with that order. Of course, the party who has an order can go and enforce it, but who will it enforce it against if the party being funded is anyways without any money? So multiple situations can arise in an international arbitration concept scenario where, and as a funder, it's very important for them to be aware of these situations and incorporate that into the contract and make the parties aware. Because if there is a dispute between the funder and the funded in the life cycle of an arbitration, then you're looking at damage which is possibly beyond your funding agreement, because then you're damaging your case and you're damaging of success or win. So it's from a win-win, it may just become a lose-lose situation for both the funder and the funded party. So it's a very interesting area which keeps developing.
Quickly adding to what Sameer said, I think I already answered that when I was responding to your previous question. In terms of India, I said that we need to develop ourselves into a mature jurisdiction for third-party funding. And before the regulation kicks in, till the time there is liberty for funders to self-regulate, and I hope the ILF and ABI SOPs can come in sooner than later to help these funders. Everybody should learn from the best jurisdictions. I mean, Australia, Singapore and Hong Kong have regulations in place. I think UK is still doing self-regulation, subject to correction. So idea is India's position in third-party funding market has already been strengthened by a judicial endorsement. Now it's for the funders to behave responsibly. It is for the parties to use funding in the right fashion. Like an example given by Sameer, that it shouldn't be as soon as a matter is funded, respondent stops paying. So there shouldn't be any exploitation through of either the target party or the party being funded by either the funder or the respondent. Till the time we can all behave responsibly, I think the position will only grow, but regulations will come in at the right time, and we should be ready for those.
In fact, Sameer sir, your inputs actually we are going to actually go through the recording and include all these changes in our legal funding agreements. Thank you so much for these insights.
Only that, Amrita, you have to send your agreement to Sameer for vetting.
I am sure, sir.
I'll
Sir,
send
I'll
them.
have to. But sir, how many NDAs will I execute in this process? I'm thinking one with the client, one with Sameer sir, between sir and client. Too many of them. But yes, sir, it was really a very these are points that we should learn from experienced advocates. Thank you for those inputs.
Okay, a pleasure.
So there are a couple of questions which I believe Ms. Amrita could answer, right?
Yes.
So let's move on to the funding structure. I think through this answer, you will be able to tackle all these questions that have been posed. How exactly
Okay.
does a funder structure their returns? And as more of these claimants begin exploring litigation funding, what are the key parameters that funders typically evaluate when someone approaches them for funding?
So for the structure part, I think I have touched on it before that, we have two formats. Structuring also is very subject to the commercial involved in the matter. I cannot give you a fixed figure. However, I have seen a range of 10 to maybe 35, 40, even 50% from the proceeds of depending on the years that will take for the recovery, because India is a very volatile field. So we don't have any straitjacket formula that can be applied for, okay, commercial suit, these many years, we'll get a result. Not that format of funding which has been internationally being used. It's quite straitjacket. We don't have that kind of regulation, a set straitjacket formula. So it depends on what we look at. Basically, when we get a brief, we usually ask for a brief note and a funding memo of what the expenses required and what the matter is basically. Then we evaluate on the basis of that. We ask for further documents or ask for queries through which we start getting documents from the client. Before all of this process, we sign an NDA and also check our records for any conflict of interest from the other side. Because with investors, we also check in depth in the investors' history if they've ever invested or partied with any of the parties. When we get the dispute, the first thing we do is a evaluation of the merits of the matter. We also check the quantum of damages that we are claiming, cost and duration of proceedings. Then enforceability of the award eventually. That, let's say that I'm going against a party where the respondent is already in insolvency proceedings, there's very bleak possibility of me recovering my money. So in those situations, yes, of course, investment, at the end of the day, the investors, some interest has to be seen. So they will not, the risk allocation in this is too much. It's just not something that is viable. So maybe investment will not fall through in a matter of this nature. Cost and duration is very important because duration actually decides the commercials eventually between the funder and the fundee. The entire quantum of damages is good, but like how many years and how much investment will it eventually take? So the four parameters basically are, the legal theory that will be applied by the advocate, the basic law which exists today to support this litigation, merits of the case, then the respondent's position, and sometimes you also consider why the client is asking for money. Let's say the client is only in insolvency, so then again I will have to go through the insolvency process to recover the thing that I have already brought maybe for them. So in that way we evaluate the case. we have to understand the investor's perspective is very different from a traditional financer's perspective. They look at the cohort of investments available with them as maybe an investment banker looks at. They get a lot of matters, but they invest in considerably fewer opportunities that are presented to them. It depends on whatever is the situation of the matter, whatever is more recoverable, and profitability also they look at. On an average, again, the takeout that they look at is maybe 3x or 5x. So that kind of arrangement is there. So this is the theory. This is my mind as, this is the mind coming from the investor's perspective.
All right. And what is the range of investment that funders actually look at in investing?
So currently, LegalPay is looking at a quantum of starting from a quantum of 100 crores to a 1,500 crores. We have both international and national investors with a investment ratio of 2 to 4 crores for a matter which is 100 crores, and 20 to 40 crores for a matter which is 1,000 or 1,500 crores. Obviously, subject to changes, we might have bigger or smaller disputes which we can fund.
Perfect. Actually, Mr. Shashankar has to another commitment and he has to jump off the call. So we'll just thank you for your time, sir. Thank you for being here. And let's move on to another last question. But before we move to the last question, we'll sincerely thank Bar and Bulletin as our media partner for the webinar. Thank you for helping spread awareness about this session within the legal landscape. So the final question that we have is regarding the respondent who finds out that the tribunal fee is being funded by a funder. So how do funders deal with a situation when the respondent finds this out?
I think sir has also already answered this question. Samir sir has already taken up this question. We'll circulate a recording of the, so whosoever has asked, please go through a recording once again and you will find your answer on this.
I believe the audience member might have joined a bit late.
Yes. So
perhaps it's okay. All right. Since we're running short on time, we'll move to the closing of remarks. Right. Third-party funding is still an evolving space in India, but discussions like these help build the understanding and dialogue necessary for the ecosystem to grow. And with that, we come to the end of today's discussion. On behalf of LegalPay, I would like to sincerely thank our distinguished panelists for sharing their valuable insights and our audience for joining us and engaging with this important conversation. Thank you all once again for being part of this session. Any closing remarks from the panel made?
No, thank you so much. I think it was very contextual and extremely relevant for the audience to understand this whole concept and hear from everyone.
Thank you, Amrita and LegalPay team for having us as the panelist to discuss our views and the way forward for third-party funding in India. It would be a welcome step if more third-party funders come and make this area more streamlined and frameworked.
I would also like to thank Mr. Lahoti. Sir, you've been my mentor all through these years, and I can't thank you enough for helping me through this. Thank you, Samir sir. I've learned so much from you today. And obviously, Shashank sir, again, one of my mentors. Thank you all for being here with us. And I would also like to thank my team, Mr. Dhruv Vadhavan, Mr. Prabpreet Singh, and Mr. Manan. You guys are great. I'm very lucky to have you in my team. Thank you all. And obviously, Bar and Bulletin for extending the media support to us. Thank you.
Thank you. Bye.
Thank you so much, everyone. If anyone from the audience would like to connect with LegalPay, explore collaboration opportunities, or learn more about third-party funding, please feel free to reach out through us on our website or LinkedIn. Have a wonderful day ahead, everyone. Thank you.
Thank you.